Welcome to Introduction to Criminal Liability, Statutory Interpretation, Understanding the Types of Elements. Quick disclaimers: if you haven't read these, hit pause, read them now. This is just an introduction to the law, specifically Maryland and U.S. federal law. Alright, we went to the CJIS manual, we found out a crime, malicious destruction. It pointed us back to the source, the statute, CR 6-301. We went to the website, we found it, and then we broke it down into elements. Well, let's practice breaking it into elements. A person may not willfully and maliciously destroy, injure, or deface the real or personal property of another where that property has a value of $1,000 or more or less than $1,000. So the value of the property only makes a difference in terms of sentencing. If it's $1,000 or more, it's a maximum penalty of 3 years. It's less than $1,000, maximum penalty of 60 days. Well, when breaking down the elements of a statute, it's useful to identify these three categories. You have the Actus Reus, or the guilty act, the Mens Rea, or the guilty mind, and the attendant circumstances, everything else that's going on. The Actus Reus is the action component of a crime. What did the person have to actually do in order to commit the crime? Well, a common law battery involves some sort of unwanted touching. The Actus Reus would be the touching. The unwanted would be something else. Another way of viewing Actus Reus might be, what does the crime look like? Which parts of the crime are outwardly observable? Those are usually the ones that are related to the Actus Reus. So what is the Actus Reus of malicious destruction? What do you have to actually do to commit the crime? A person may not willfully and maliciously destroy, injure, or deface the real or personal property of another where that property has a value of $1,000 or more or less than $1,000. Well, we don't care about a person may not, right? That's in everything. Willfully and maliciously, that doesn't sound like something you do. Destroy, injure, or deface, all right, there, now we're talking. The real or personal property of another where that property has a value of $1,000 or more or less than $1,000. So the property's value, all right, that's not what we do. Destroy, injure, or deface, yes. The real or personal property, yes. Of another. Well, of another is not something we do. That's the quality of something. So what we're left with is destroy, injure, or deface the real or personal property. So if you destroy, injure, or deface real or personal property, that is the Actus Reus for malicious destruction. The Mens Rea is the state of mind at the time of the crime. What is it that the person wants, or what's the person thinking? What was their intention? So if it's against the law to intentionally wear white after Labor Day, then intentionally would be the Mens Rea. It's what the person was thinking when they committed the Actus Reus. So if it's against the law to intentionally wear white, then the Actus Reus, what the person has to do, is wear white. The Mens Rea, their state of mind when they were doing it, is intentionally. But what does it mean to act intentionally? Is there a range of Mens Rea from least to most intentional? Well, that's sort of what the Model Penal Code tried to give us. They suggested 4 different levels of Mens Rea: purposely, knowingly, recklessly, and negligently. Now, the Model Penal Code was developed by a bunch of lawyers and judges that got together and tried to come up with an idea about how a criminal justice system should be. Nowhere has actually implemented the Model Penal Code, definitely not all of it, but it provided a model to work off of for state governments and local governments that were trying to come up with their own criminal justice system or modify their system to improve it. So the Model Penal Code suggested 4 different levels of Mens Rea. Purposely, that you wanted it to happen. Knowingly, you knew it was going to happen. Recklessly, you knew it was probably going to happen. And negligently, you should have known it was probably going to happen. So let's look at purposely first. Purposely means that it's the goal you're trying to achieve. So if that's the Mens Rea, that means that whatever the Actus Reus was, that is the goal you were trying to achieve, or the result is the result you were trying to achieve. Purposely and intentionally are considered equivalent. So if you throw a baseball and you hit someone in the head, You did it purposely if you wanted to hit them in the head with the baseball. Knowingly means you're aware that something will happen, but it's not your goal. You're just virtually certain that that's going to be the result. So if you throw a baseball and you hit somebody in the head, you did it knowingly if they were standing in front of where you were going to throw the ball. So you were just trying to throw the ball straight. You knew it was going to hit them. You just didn't care. If that's the case, you did it knowingly. Recklessly means you're aware of a substantial and unjustified risk that something will happen, and that something is a significant leap from what a reasonable person would do. So if you throw a baseball into a crowd trying to knock a bottle out of someone's hand and you end up hitting someone in the head, you did it recklessly if you knew there was a good chance that was going to happen, because no reasonable person would have tried. Negligently means you should have been aware of a substantial risk, but you weren't. A reasonable person would have noticed the risk, and obviously a reasonable person would have avoided it. Now keep in mind that civil negligence is not the same as criminal negligence. Criminal negligence isn't just a mistake. It's a gross deviation from what a reasonable person would do under the circumstances. So while driving in the city, you look down quickly to check your phone, you end up rear-ending the car in front of you. That would be an example of civil negligence, but not criminal negligence. While driving 70 miles an hour on the highway, you look down to check your phone, and you see that your friend sent you a funny video. Without looking up, you watch the video for 10 seconds when you hit the guardrail, overcorrect your steering by grabbing the wheel, and turn into the car next to you. That would be both criminal and civil negligence. So in terms of intentionality, it goes from civil negligence, which is an accident, criminal negligence, which is something where a reasonable person would have realized that something bad was going to happen and not done it, reckless, meaning that you realized that something bad was probably going to happen and no reasonable person would have done it, knowing, where you knew something was going to happen but you did it anyway, and intentional, you knew something was going to happen and you did it because that's what you wanted to happen. So let's go back to malicious destruction. What is the mens rea of malicious destruction? What has to be going on in your head to commit the crime? Well, a person may not, alright, we already know, we're ignoring that part. Willfully and maliciously. Well, that sounds like things that are going on in your head. Destroy, injure, or deface the real or personal property. Alright, we already said that was the Actus Reus. Of another, where that property has a value of $1,000 or more, or $1,000 or less. That's not what's going on in our head. That's just something else that's going on. So it looks like the mens rea here is willfully and maliciously. So the model penal code has its 4 levels of mens rea. Each level is clearly defined. It was created by one enacting authority, and you can turn to one page and see all the definitions for all the different levels of mens rea. Maryland, on the other hand, has no limit on the number of types of mens rea. The same words, in fact, may be defined differently in one statute versus a different statute. They were created by different groups at different times. Remember that some of Maryland law comes from common law. So England 1700s versus some of the law which was established last year, 2015, Maryland. Very different places. In addition to the different types of mens rea, there are different types of crimes and how they apply mens rea. You have general intent, specific intent, and strict liability. A crime is a general intent crime where all you have to do is intend to commit the actus reus. You don't need to want anything to happen. You just need to intend the action. As the Court of Appeals said, when the definition of a crime consists only of the description of a particular act without reference to intent to do a further act or achieve a further consequence, we ask whether the defendant intended to do the proscribed act. This intention is deemed to be a general intent crime. So, if all it says is this thing, this actus reus is illegal, then it is a general intent crime. So if it's a crime to touch the Washington Monument, what's the mens rea? Well, this is a general intent crime because it only describes an actus reus. When you have to do something other than just intentionally commit an actus reus, we refer to this as a specific intent crime. A specific intent crime specifies the mens rea required. It normally involves a mens rea beyond general intent. So a general intent crime is just you have to intentionally commit the actus reus, so intentionally touch the Washington Monument, in that past example. A specific intent crime goes beyond that. When the definition of a crime refers to a defendant's intent to do some further act or achieve some additional consequence, the crime is deemed to be one of specific intent. If it's a crime to wear white with the intent of showing your undergarments, what's the mens rea? It's beyond just intentionally wearing white. You have to wear white with the intent of showing your undergarments. If the result of the crime has a mens rea, then it's usually a specific intent crime as well. So if you have to destroy property and willfully cause over $500 in damage, that's also a specific intent crime because you have to do more than just intentionally destroy property. Now, proving mens rea can be very difficult, especially with a specific intent crime. You can assume that people usually intend their actions, but how do you look inside someone's head to figure out why they did something? Strict liability is the most harsh of the three. There is no mens rea requirement at all, and therefore you can commit the crime unintentionally. The only question before the court in a strict liability case is, did you do it? There is no why did you do it. Because strict liability is so harsh, it's mostly limited to minor infractions such as speeding. Nobody cares why you were speeding. If you were speeding, you get a ticket. Attendant circumstance is the third part, the third type of element. It's just what else is going on. Attendant means accompanying or resulting. The attendant circumstances element consists of all other parts of the crime, either accompanying the actus reus or resulting from it. When you break a crime down into actus reus and mens rea, everything else is normally the attendant circumstance. Now, there used to be a separate crime for intentionally breaking into a house at night with the intent to commit theft. So the actus reus would be breaking into the house. The mens rea would be doing it intentionally and doing it in order to steal. The attendant circumstance would be that it happened at nighttime. So what is the attendant circumstance of malicious destruction? Other than what you are doing and thinking, well, what else is left? Well, a person may not. Okay, that's just telling us it's a crime. Willfully and maliciously. All right, well, that's going to be the mens rea. Destroy, injure, or deface the real or personal property. All right, well, that's the actus reus. Of another, where that property has a value of $1,000 or more, or less than $1,000. So the attendant circumstances would be that it was of another and the value of the property. So this may seem like a very complicated way to do something you could probably do in your head before, but that's because we've only been looking at very simple statutes. Knowing that you need to identify the mens rea for each actus reus and, if relevant, attendant circumstance helps you find elements that you might have missed otherwise. Basically, it helps you break down a crime and figure out what needs to be in someone's head, what else needs to be happening here, other than what you might just look at and see. So suppose that a statute reads, "It is illegal to intentionally use a computer on a Wednesday." Well, would you only have to intentionally use the computer? Or do you have to intend to use the computer on a Wednesday? Is it a defense that you thought it was Tuesday? And that has to do with associating the mens rea with an attendant circumstance. This comes to a head with 18 U.S.C. 1030 A2C, the broadest provision of the CFAA. Someone who intentionally accesses a computer without authorization or exceeds authorized access, and thereby obtains information from any protected computer, is punished under the CFAA. So, do you need to intentionally obtain information? Or is intentionally accessing the computer enough, even if you just accidentally obtain information? That's something we'll discuss more later. So tune in next time when we take a look at case law. And other than that, thanks for tuning in.